And we're live. Hi, happy Thursday after
Hello.
o'clock.
Hi.
COVID to all of you. I'm going to do some quick housekeeping items, and then we're going to get started. Today's presentation, I'm looking forward to probably more than any other one that we've done. As a former attorney and CPA, I kind of love this stuff, but I think our audience is going to get more out of this than they thought when they first logged in. So hang tight, and we'll start in a second. I'll get through some housekeeping items. First thing I got to do, this is us, Red News and RE Journals. We publish 6 publications in 17 different states. We were supposed to have 104 live events this year. We've had to pivot into webinars. We could not do it without sponsors. So I want to express gratitude to Insurance Claim Recovery Support, SIOR, Lloyd Law Firm, and PDS Forensic Accounting. Without sponsors, we wouldn't have been able to still bring you, even though we can't be face to face, at least we can bring you faces and bring you information. And so deep appreciation for the folks that have allowed to make this happen. Again, this is us. In case you're in Texas and you didn't know that Red News joined a bigger group, we're growing. We've added 2 new people in the last month in Texas, and we're going to bring you lots of good stuff in the future. If you have connection issues, if you're watching this online right now or on your phone, there should be a button right above where it says connection issues that says reconnect. If I'm showing 5 bars on our dedicated server, and all of our speakers have good connections right now. So if you see somebody glitch out or your screen freezes, it's probably your connection. The simplest thing to do, hit that reconnect button. That solves 99% of the problems. If that's not solving your problems, Google Chrome works the best. Even if you're on your cell phone, if you can bring up Google Chrome, that's the #1 way to view it. Close to 200 today. So that'd be a great way to get in and meet some people. But more importantly, this is where you're going to ask questions of our speakers. So as you add them here, I'll flag them as a question. If it fits into the conversation, our speakers can pick it up and answer it right then. But we'll save some time at the end for that as well. I'll put up a poll as well too. That'll just pop up on the right-hand side of your screen. So if you could help us out with that, sometimes they're kind of fun. Last but not least, we have our own YouTube channel now and a place where we keep all of our prior videos. So right now we probably have 30 videos out there from webinars we've done, and this one will also be there. rejournals.com/videos. That's our parent company, RE Journals, and that's where you'll find them. But here we go, navigating COVID-19 business interruption losses. I'm going to take these slides down. Scott, I'm going to let you take it from here, and I'll bring up your slides when you're ready. So go ahead and take us away.
Thank you very much, Todd. Hey, good morning, everybody. Thank you for joining us. I know everybody's got a lot on their plate, and we promise that this will be a very informative webinar. I'm Scott Friedson. I'm the CEO of Insurance Claim Recovery Support. I'm a public adjuster with 11 years of experience. We specialize in commercial and multifamily insurance claims, and a lot of people don't know what a public adjuster is, but basically we are adjusters that are authorized and licensed to negotiate insurance claims on behalf of policyholders. And whenever there is a commercial loss like a fire or a flood at, say, an apartment complex or a retail strip center, where there's physical damage, there's also another loss that gets triggered typically, and that is a business interruption loss. So we're very accustomed to dealing with business interruption loss claims. And now in today's world, there's been a lot of disputes and interpretations going on as it surrounds this completely uncharted territory that we have entered into regarding COVID-19 insurance claims. So I want to make sure that first and foremost, that we want to manage upfront expectations, and that is that we are in uncharted territory. Nobody knows exactly what's going to happen or how this is all going to shake out. We are not trying to give false hope or legal advice that should be relied on or guarantee any type of outcome. The policy language is in the circumstances may apply or may not apply to your situation. And it's very, very important that you read the entire policy and understand it. That being said, there's also, we have discovered a lot of ambiguities. And when this all first started out with just a virus going around, like other situations, whether it was, West Niles or malaria or whatever, or just the flu season in general, we just need to be cautious. Society needs to be cautious like normal. So it is what it is. This is a different virus. Then when civil orders were issued to shut down businesses, that's when we kind of went, that's interesting. The entire country has just been shut down due to government orders. That has caused an enormous disruption among many, many, many businesses. And the ensuing result has been an extremely large economic loss to a number of policyholders who have in turn looked to their insurance companies and said, hey, this should be covered, right? So a number of people have turned in claims. And if you're like a lot of other policyholders that we've been working with, we've gotten responses that verbatim say it is this insurance company's opinion that this loss was caused by the coronavirus, COVID-19. So when we have an insurance claim, we look for evidence, we look for facts, and the policyholder does carry the burden of proving their claim. And Shannon Lloyd, who's a board certified attorney, is going to join us and talk about that. And also Bruce Smith, who is a forensic CPA, is also going to talk about how to package a business interruption loss. But if we could go to the first slide, Todd, maybe the second slide. I think you're going reverse. That's the disclaimer. I think do we cover that? Yeah. Still going the wrong way. One more. There we go. So let's talk about the importance of these executive orders. The executive orders, not the coronavirus, is our position, is what caused this pandemic, which caused the business to shut down. They are ordered to stop the spread of or prevent the spread of a virus for health and safety purposes. And the resulting loss of business income sustained by policyholders due to civil authority orders were enacted to slow the spread of COVID-19 in the area. And that's arguably the loss that's covered by many business insurance policies. And some orders have language that state the virus causes physical loss or damage to the property. And that's important. And Shannon, do you want to maybe shed some light on the importance of those orders and what your opinions are on that?
Sure. Well, all the orders are different. There's state orders, there's county orders. And so, in most situations, businesses are closed down or shuttered because of both the state and the local order. And so some of the orders were written maybe by policyholder lawyers, I don't know, but they include language that the virus causes physical loss or damage, and some of them do not. But we maintain that doesn't matter. The order, as Scott was saying, the order to shut down or to slow down for restaurants, for example, is what caused the loss, and that's true. Another thing that causes the loss of business income is the fear of the virus. And so lots of consumers aren't going out because they're afraid of the virus. And if you could go to the next slide, I want to move on from something Scott was talking about. I think it's important for everybody to know, being in the industry, being an insurance lawyer for the past 15 years, it's back. Let me go back one more. Actually, go forward. I'm sorry. One more. Okay, go back. Never mind. Never mind the slides. What we saw, policyholder lawyers like myself, what we saw very clearly starting in February was the carriers doing a full court press, putting out the narrative, trying to set the narrative to all the businesses across the United States that there's no coverage for their interruption because of COVID-19. They enlisted the help of defense attorneys to put out white papers, to put out articles. They enlisted the help, unusually, of agents even. The agents are telling people that they don't have coverage, which is very odd because agents have no duty to explain coverage to their clients. And so the question is, what are they doing telling policyholders they don't have coverage and explaining why? And what we're finding out is it's because the carriers have given them talking points to tell the policyholders. And the whole point of this is to keep the businesses from even making a claim. Because the less claims that are made, the less they'll have to deal with.
And so that I think that's a good segue to the question is, should you file a business interruption loss claim right now? And I think the answer that we all agree on is emphatically yes. We've even seen articles with defense attorneys that have stated to do it. Your policy language typically states that the duty of the policyholder in the event of a loss or damage is to provide your insurance company prompt notice.
And we have a slide on that, Scott.
Yeah, go ahead and can we pull that slide up? It's number 5. There you go. Thank you. So your duties are prompt notice, mitigation, cooperation with the investigation, and I think it would be even fair to say that you're supposed to comply with the civil orders. And if you don't comply with civil orders, there are penalties. And so, this is, I don't see any argument that's reasonable that the orders that were issued by city, county, state, federal government is the cause of these businesses shutting down. Not the virus. The virus didn't write the orders. The virus didn't stand in front of a restaurant and say, you can't come in here. The virus didn't prohibit people from leaving their houses, the customers of these businesses that have been impacted. So I think we're all in agreement that if you think you have a covered loss, or if you have a loss that should be covered by your policy, you should file it.
And let's back up to the last slide right there. Good, because these are the types of coverages that business owners can look to in their policy. Business income, in some policies, it's called lost time. There's lost rents. If you're a landlord and your renter has either moved out or stopped paying rent, there's extra expense, there's civil authority. And in some policies, we're seeing they actually have coverage for communicable disease. So if you look to your policy or even reach out to your agent to ask about coverage and to submit a claim, be prepared. We're seeing that agents are giving a lot of pushback and trying to dissuade policyholders from even making a claim. If that happens to you, insist that the agent submit the claim. Because as we said in the prior slide, you have a duty to promptly notify your carrier of a loss. So you want to go forward?
Yeah, let's go to the next slide. We already got that one.
Okay.
Yeah,
I talked about this already, so we can go to the next one.
What options do policyholders have? So a lot of people are filing their claims on their own, and they're getting these denials of coverage based on opinion. My first suggestion would be try it on your own. Try to settle your claim on your own. Ask your insurance company for facts that support their position. I was on a phone call yesterday for 2 hours with a very large national insurance company, and I straight up asked them, what do you have that supports your opinion for denial of coverage? We view this as absent of any evidence that supports it. We don't think that you guys have any defense for coverage, for denying coverage. How do we get that reversed? Their response is, we have to provide facts. Well, we have provided facts. Not only have we provided facts, the facts are the civil order, the facts of the language of the civil order. The facts are the interpretation of the policy, and more importantly, or as important, the policy lacks definitions which would reasonably be relied on by a policyholder to understand what their coverage is. So the options for the policyholder are to try it on your own. An insurance broker has an authority, can try to settle a claim. A public adjuster has authority to negotiate and settle a claim, and attorneys obviously have the authority to settle claims. I think one of the big things that I want our audience to also understand is that when we represent a client, we are submitting. My responses are around over 100 pages long. That includes their financial losses. That includes definitions of our interpretation of the policy, which are not clearly defined. It includes what other authorities have ruled on ambiguities, what the definition of physical loss is, and we'll get into all of that. We'll let Shannon and Bruce can get into that. But that is our argument. That is our supporting documentation. And one of the things that I think is important is that, and I want Shannon to talk about this, is while we are arguing, we're presenting factual information to these insurance companies at this time, and we're giving them the opportunity to rebut or to support their positions for denial, which they're not, by the way. When somebody files a lawsuit, what can you talk maybe about those steps of what's involved, Shannon? Like when an attorney files the lawsuit, are they stating their case as to why and what is wrong with the carrier's position and how the policyholder is producing their evidence that supports their burden of proving their claim at the time when you file it, or is that something that gets argued later? How does that work?
Well, I mean, you submit the claim, you say, I have a loss of business income. We've been shut down by the civil orders, or maybe you even have a type of business where, like one of my clients caters to cancer patients. And obviously there's a fear of the virus. And so the business is, even though it wasn't shut down by an order, it has slowed severely. Or like hospitals who are not allowed to do elective surgeries. And so you submit the claim for loss of business income, and you answer any questions that the carrier asks, and you give the basis of why you're losing the income, and then that's pretty much the crux of it. With these cases, with these business interruption cases, it's not like a hail claim or something like that. This is going to be a legal argument. And as Scott, as you said earlier, we're in uncharted territory. There's not been a case directly on point with this. The closest case that I could find to what we have happening here is a case from Michigan, from the Detroit riots back in the late 60s, where the Michigan Supreme Court said the curfew order was a physical loss that caused the business to lose income. But so, what happens is once it's denied, and they won't change their mind on the denial, well, then we file the lawsuit, and then we ask the judge to determine the coverage under the policy. Because whether a policy covers something or not, whether an exclusion applies or not, is a matter of law for a judge to decide.
I think we've got some questions. Do we want to answer some of these questions here? It says, what if your policy says that there must be physical damage to your office for loss of business income coverage to kick in?
I can't see any questions.
Oh, it's on the chat.
Okay, are you talking about the question from Michael Casa?
Casa. Uh-huh.
Okay. Good question, because this is the key thing the carriers are focused on. You don't have physical damage to your property, therefore you have no covered claim. But that's not the case with most of the policies. Most of the policies that are all risk policies say physical loss of or damage to the property. The word "or" is very important. I mean, obviously, the physical loss of property is one way to trigger coverage. Physical damage to property is another way to trigger coverage. But the carriers are focusing on the physical damage part. And we argue that there's two ways, not just one. Obviously, if the carriers, like I was saying earlier, they started very early with the press, with articles, with using agents to tell policyholders, you don't have any physical damage, so you don't have a claim. And if you think about it, and again, as Scott said earlier, I'm expressing my opinions. I'm not giving legal advice. My opinion is that they did that mass campaign to keep people from making claims, because the less claims they have on the table, the better for them. But we believe we have good arguments for the coverage, but it's going to end up being, for the courts to decide.
And physical damage, like the example we gave earlier about the apartment fire, right? The fire itself is the physical damage. I think everybody understands that. The loss, though, is the loss of business income, right? So when I was on the call yesterday with this manager from this huge national insurance company, I asked them to decipher the difference between the physical damage in this example and the physical loss. And they couldn't. So at the end of this call, I literally asked them, I begged them, please provide me with something factual that supports your opinion. And I'll be happy to present it to the insurance company. I mean, to my policyholder. Please provide me some kind of rebuttal that refutes what we have submitted, and we'll be happy to review it. But the responses that we've been getting have been one and two sentences, like we've answered all your questions.
Hey, Scott, let's go back to the PowerPoint, because I think the next slide has where we talk about the physical damage.
Next one. There we go.
Okay.
Perfect.
So for everyone, here's some examples of how physical loss is not always required. Actual physical damage is not always required to prove a physical loss. So in this one case from the Fifth Circuit, which is the federal court in Texas that covers Texas and Louisiana, the Fifth Circuit has not defined but strongly implied that physical loss or damage means a change by some external event from an initial satisfactory state to an unsatisfactory state. Well, if you are a profitable, growing business, and now you're not, well, you've obviously gone from a satisfactory state to an unsatisfactory state. And in addition, we've got the case from Colorado, where the fire department made a family move out of their house because of the possibility of falling boulders. Well, that qualified, the possibility of a falling boulder, that qualified as a physical loss. There's many cases addressing ammonia, asbestos, and other agents that don't cause clear structural damage, but that courts have held constituted a physical loss to the property. And so, obviously, if the orders were put in place to stop the spread of the virus, or the threat of the virus, then that's obviously a physical loss.
And I just want to add on to something with that. I mean, we Shannon and I, every plaintiff attorney and almost every public adjuster, all work on contingency. And we don't just take claims just for the sake of taking claims, but we feel if there's a strong argument that reasonably demonstrates that the insurance company has liability, then we're all over it. If it can be done, it will be done. And when I first started looking at this, and Shannon and I've we've worked together for years, and we talk about this all the time, how this as this unfolded. And at first, when I thought, well, okay, to prevent the spread of, okay, well whatever. But Shannon, if you could, can you expand a little bit on how the language in one area of the policy, if it's not like we talked about the asbestos and the lead paint, and how that, it's like, well, geez, I mean, let's not forget first and foremost that an insurance policy is a contract of adhesion, whereby the consumer has absolutely no negotiating power. It's take it or leave it. And the premise of that is the reason why insurance companies are obligated to act in good faith. And they're not supposed to be looking for reasons to deny coverage. They're supposed to be looking for reasons to extend it. So
Right. Well, so, and you and I were just thinking the same thing. So in your policy, well, first, before that, as we were saying earlier, the carrier has the burden to prove any exclusion applies. And in addition to that, if there's any ambiguity in the policy, the law construes the ambiguity in favor of finding coverage. And so the other thing everyone needs to understand is, if the policy doesn't define certain terms, like for example on the slide, physical loss or damage, if that's not defined in the policy, then most courts look to the common, ordinary, everyday meaning of the word in your dictionary, not the legal meaning, not the industry meaning, but the common, ordinary meaning. And so if you look up physical loss or damage or direct physical loss or damage, you'll see they're very broadly defined. But what's interesting too is that if you look in the liability portion of your policy, most insurance companies have actually defined a physical damage or physical injury, and they've defined it as being a tangible damage. And so they have that in the liability portion part of the policy. They could have defined physical loss or damage, the trigger for business interruption. They could have defined that like they did in the liability portion, but they didn't. And so, the law, most areas, the law assumes if you have language one place and you don't have it in the other place, you meant to leave it out. And so this is why we are arguing that physical loss does not require actual physical damage.
Right. And while we're on the subject of case laws, and since you're the attorney, do we want to mention anything about that Houston Casualty case about?
I don't want to get into the too much case law right now, but I see we have a question.
Yeah, let's go to the questions.
Lynn
I got
Edmonds.
Oh, Todd's got one. Go ahead, Todd.
Since I have you guys captive audience, I want to ask about our situation. So we're in the event business. We have a policy. All of our event venues require us to have property casualty insurance. It has a business interruption clause in it. We filed a claim right away and were denied. So first part of that is it worth pursuing? We're in Minnesota, different jurisdiction, but also if we do, what are the next steps? Because us, like Lynn, have been told you got nothing. So what do we do now?
Well, so I'd tell Lynn Edmondson to call a carrier on your own. And if your agent was unwilling to file a claim after this is all over, I'd find a new agent. But go ahead, Scott, you start that for Todd.
Well, I think the very first thing we have to do is we need to review the policy, and we need to read the entire policy. That is,
because all policies are different.
All different. Every single one of them has been different. There are a lot of similarities, but it's those. This is a wordsmithing. This is the devil's in the details situation. So what I want to see is the full policy. I want to see the insurance company's response for the denial of coverage, and then we can respond accordingly. And again and again and again, we all understand that and it's important that you understand the policyholder has the burden of proof. Okay, so in our claim files that we are submitting, the way that we are doing that is we are pointing to the orders to shut down. That is the cause. We are providing financial income statements that memorializes the loss, and we are also looking to policy for definitions, and where they lack definitions, we are inserting definitions in plain language per Merriam-Webster's dictionary. And then what was the other thing? The other thing that we're doing, and this is also very important, and anybody can do this, is look at what the marketing representations are that your insurance company has put out to you. Because again, this is a contract of adhesion whereby you have no negotiating power. All you can do is rely on the representations from the insurance company. And if the insurance company's representations lead you to believe or induce you to purchase this coverage or purchase their product because of their representations, I'm pointing to them as well. Did I answer your question?
I think that's great, but I think the answer is I need professional help at this point, because what you're saying is it could be one or two words buried anywhere in the entire contract, even though it may look on its face like it doesn't cover or that it does cover it. I still could be faced with contrary language or other issues.
So I think that the multi-trillion-dollar question on everybody's mind is what's going to happen? And so, I could be wrong. This is my opinion. One of three things is going to happen. Okay. I think either insurance companies are going to be forced to pay these claims and they're going to crash because there's no business model on the planet for insurance companies where their actuaries built in, well, if the entire United States economy shuts down, we've got that built in. Okay. Nobody foresaw that. Although, again, there's been SARS, there's been viruses in other countries. So it's not that they aren't aware, and they are in the risk business. So, that's kind of like insurance company. That's, you took that risk on when you took our premiums, right? Number two scenario would be the insurance companies aren't forced to pay anything. They have to defend a lot of lawsuits. And in that process, a number of businesses file for bankruptcy and foreclosure. Which is also terrible. Under both of those scenarios, future insurance and premiums, I can't imagine what's going to happen to premiums and to coverage and the language of what you can and can't get covered. The third option, which I think is hopeful and the most reasonable, but haven't seen any evidence that this is actually going to materialize, although I hear rumors, is my belief is that somehow the federal government needs to backstop the insurance companies and share some of that risk on a pro rata basis. And I know that they've done that with some other scenarios, not on a national level, but I mean, we've just fired off $2 trillion and are talking about firing off another $3 trillion. And, we're going into an election. So those are the three scenarios that I see, as how this shakes out. But even if there is some kind of agreement made whereby insurance companies, okay, now you process these claims and work with policyholders and their representatives, there's still going to be negotiations. There's still going to be, hearings, I would guess. And so I think we're unfortunately a long way from reaching some kind of resolution and closure.
Scott, do you want to go, or I'm sorry, Todd, to the next slide? Okay, thanks. I wanted to talk about more specifically with everyone about civil authority. I've always thought civil authority was really the best argument for coverage that we had. And we've got an example of what a typical civil authority provision says there in the policy. And so the type of denials that I'm seeing are, as we said before, you have no physical damage to properties around your property. I've seen the denial based on, well, you still have access to your property. You're still allowed to go to your property and clean it and protect it, which is really a ridiculous argument. But those are the type of denials that we're seeing. But really, the civil authority, most civil authority is the trigger for it is that you have a covered cause of loss. And most of these all risk policies, as we've talked about earlier, the covered cause of loss is usually a risk of direct physical direct physical loss of or damage to the property. And so again, going back to focusing on the physical loss part of it, as we did earlier, that's where you would get your coverage triggered. And then do we have another question, or?
We have several.
I guess I can't see them all.
Oh,
I can go ahead. I can read one to you if you want to read. Steven Seltzer. I have a tenant who is moving towards a default on their lease. This was prior to the pandemic scenario. Under my loss, rents, recovery, under my policy, if my carrier approves the claim, can I recover the rent from this particular tenant?
Bruce? Scott? I want to get Bruce in here too. He hasn't been able to talk
I mean,
yet.
that sounds like a breach of contract question. Moving towards and actually breaking it, I think might be two different things. I'm not an attorney. I guess we'd have to see what the policy says.
Yeah, I think you'd have to look at the policy.
Yeah.
Let's go to the next slide. I have a case example of civil authority. So this case, in this case, it was interesting because the court held that there was physical loss because of the civil closure evacuation order, because and a civil authority requires a covered cause of loss causing damage around your property. Well, in this case, they held that the county officials issued the order after watching the storm progress and causing damage in its path. And so you can see that's a very similar situation to what we have here, is the spread of the virus across the United States, county and officials and governors seeing that happening and then issuing the civil authority to stop the spread. And so this is a pretty good case to show that you should have coverage for civil authority in these situations.
Can we go to the elements of business loss claim slide? Is that okay, or did you want to talk about that?
Bruce, you jump in here, and then we'll go back to the.
Yeah, because I'm sure we'll probably have some questions about this. So go ahead, Bruce. This is
okay. I'm Bruce Smith. I'm a forensic accountant. I've been doing this since 1992 and been involved in most of the major disasters since that time. The first one happened to be Hurricane Andrew, and outside of the insurance area and business interruption, I was also involved in the Deepwater Horizon claims too, which is, to me, is the most similar to this situation. But what I'm going to go through is how I deal with a claim and what's in my mind as it starts. And the first thing that I look at is the chain rule, and hopefully the public adjuster, and definitely I hope the attorney, if attorney's involved, knows these different factors, whether the claim is covered or not. And I'm just going to go through the different steps. And as you can see, when I go through it, I think each one of these, they look like they're definite items, but they're subject to interpretation. The first thing in the chain is you have to have a direct physical loss. And the second is you have to know what properties has the physical loss. Then if it's from a covered cause or type, and what type of loss, and whether there's any exclusion applies, and whether this causes an interruption of business. The damage has to cause an interruption of business. A quick example of where it doesn't, let's say there's some damage to an office within the building. Well, there's physical damage, but does it cause an interruption to the full workflow and capacity of the business? Probably not. So you probably wouldn't have a business interruption claim. The next thing I do, once hopefully that there is a covered loss and the public adjuster gives me the okay, or the attorney, even though I'm not involved in the coverage, I like to always review the business income coverage, business interruption coverage. And the one that I see the most is an ISO form, which is an insurance service organization. They put out forms for many of the major carriers to use, basically. And the one that I see the most is called the CP0030. It's called business income and extra expense. And I'm just going to read what the coverage is and tell you what I think the important points are. It says, we will pay for the actual loss. Well, there's got to be an actual loss of income, business income. Again, going back to that office damage example I gave you. So we'll pay for the actual loss of business income you sustained due to the necessary suspension of your operations during the period of restoration. The period of restoration, I'm going to go into that a little bit more in a bit, but that's a very important thing. And it's going to be kind of an issue with this COVID, these COVID claims. And the suspension must be caused by direct physical damage to the property at the described premises. Some of the particular features of the policy that...
Bruce, I don't mean to interrupt you, but
go ahead.
Doesn't it say direct physical loss of or damage to the property at the described premise?
In a lot of the policies, yes.
Okay. All right.
I know that's one of the arguments you're talking about.
Yeah. Okay. Go ahead. Sorry. Just want to make sure that we're clear on that. Not just physical damage. Go ahead.
Right.
Okay.
Or I think I said physical loss, but it doesn't matter. So some of the features in the business income policy that, and these just don't relate to COVID claims. As a matter of fact, COVID is a very unusual type of claim, but just in general, they typically have a waiting period. Sometimes it's 72 hours, sometimes 24 hours before the coverage kicks in. In other words, if your loss is on January 1st, your coverage for business income won't start till January 4th. Sometimes there's monthly limits of indemnity. What that means is you'll see on the policy, on the declaration page, you'll see something that says, for instance, 1/3, and it will say limit of 300,000. That means the most that they'll pay you is 300,000, and the most they'll pay you in any month is 1/3 of that, or $100,000. Now, what that sometimes that can hurt you, because let's say you just have a month loss, you're out for a month, and you have a $200,000 loss. Well, they're not going to pay you $200,000, even though your limit is 300,000. They're going to pay you a maximum of $100,000. So you're going to have to come out of your pocket for $100,000. Another feature that you'll see in these policies, and most policies, is extended business income coverage. I'm going to talk a little bit more about that in a bit. And then another feature in the policies that you'll see in a lot of the policies is an ordinary payroll limit. What that is, you're entitled in your business income policy to your net profit plus your expenses that you continue to incur during the loss period. When they have these ordinary payroll limits, it might be 60 days. So say ordinary payroll, 60 days. What that means is for your ordinary payroll, which is typically everyone but the officers, managers, and other key people, they'll only pay those people, first of all, if you incur the expense, and second of all, they'll only pay it for 60 days if that's the limit. So if your loss is 12 months, well, they're only going to pay you for the first couple of months for your continuing payroll, ordinary payroll. And then going down to the next feature that they have is the second part of the business income coverage, which in this particular policy says business income and extra expense. And the important part in this is that the extra expense has to be incurred during the period of restoration. And again, I'll explain the period of restoration in a little bit more detail in a bit. And some of the extra expenses, extra expense are additional expenses that you incur due to the loss to your property. Some of the ones that I typically see are if a business relocates to a different location, they'll pay you to set up the new location, your moving costs, maybe if there's extra labor involved. And another important one is advertising to get back in business. Typically, you have to, in extra expense coverage, the expense has to be incurred during the period of restoration. So I always advise, if the public adjuster doesn't know, or if their client asks me, I say, if you're going to do some advertising, try and do it before you're back in business. And therefore you'll have less of an argument. You'll probably still have some argument and discussion about it, but that's very important. And then the final one I'm going to talk about, as far as there's of course a lot of other issues in the policy, but is dependent BI coverage, that is contingent BI coverage. And what this covers is for if you have one of your customers or suppliers has a covered type of loss, this is what's covered in your policy, but they have the loss, you can file a claim under this coverage for the loss that's resulting from your supplier not being able to supply you the goods you need to sell, or your customers not being able to accept your product anymore. Okay, let's see. The next thing we have, understanding the business. In my business, it's very important to understand what the business is, what the client, what they do. Pretty much it's divided between, in my world, is divided between retail, wholesale, manufacturing, and I do a lot of medical practices too. Some of the things I want to know is if the business is seasonal. That's very important, especially in shorter time periods where you're measuring the loss. I want to know how they keep their books for accountants, if it's on accrual basis or cash or some type of hybrid method. I want to know if there's any trends in their business, if there's any contracts that are enforced at the date of loss that are going to be continuing expenses. And I want to know if there's any recent additional capacity that was in the, let's say if you bought some additional machinery right before the date of loss, well, you probably were going to be doing or had the plans to do a lot more business than maybe your historical records show. So I want to know that, so maybe the projections of what you would have done are going to change from what the historical records show. You know, that goes with new employees or with equipment. Okay, and the next one I'm going to talk, sorry if I'm talking a little bit fast, but I want to try and get through this, is the period of restoration. I want to go back to that. Under the policy, the insurance companies are only liable if they follow what they're supposed to do. It doesn't go to a bad faith type of suit. They're liable only during the period of restoration. And the period of restoration is the length of time required to rebuild, repair, or replace the damaged property or destroyed property. And the period of restoration, like I brought up before, typically starts either at the date of loss, depending on the policy, date of loss, or maybe 24 or 72 hours after the date of loss. And it ends when the property should be, with reasonable speed, be repaired or replaced. And what I do, I really don't have anything to do with that. I'm given that information either from a public adjuster or an attorney, and they might get it from an architect, engineer, or a construction person who can give them an idea how long it's going to take to get their business, the property restored. And the second part I brought up before is the extended period of indemnity. That's like an additional period that they give you. And to me, this is very, very important. Typically, the policies will give you an extended period of indemnity of 30 or 60 days. And what the extended period of indemnity, what this does, it starts when the period of restoration is over with. And then it will give you another, depending on what the policy says or what you may purchase, 30 or 60 days to ramp up your business. So if you don't have that type of coverage, once the property is replaced, repaired, it's done. You're done as far as the loss goes. If you don't have this extended business income coverage or extended period of indemnity, you're done. With that, and I've seen it go up to, you have to purchase it, but like I said, the typical policies might have 30 or 60 days, but I've seen it as long as 720 days. And for some businesses, they need it. They need it to get their customers back. You know, once you lose a customer, it's very difficult to get them back. And if you don't have this coverage, you know, even if the insurance company pays the rightful amount for the period of restoration, it might not be good enough for you.
Hey, Bruce, I don't mean to cut you off, but can we jump to the loss formula, the business income loss formula? Sure. Because we've got we want to get to the virus exclusion, and then we've got several other questions. Thanks.
Okay. The business income loss is calculated. It's two different ways you can do it, and you end up with the same amount. You might find policies called gross earnings policies, and what they'll do, they'll start with the sales, your projected sales that you lost, and they take away from that amount any expenses that are saved because you're not running at full capacity. Then there's the business income policy, which I was talking with before, that covers you for your lost net income plus continuing expenses. So one's starting at the top and going down, and the one that's in the business income policy started at the bottom, net profit, plus adding the continuing expenses, and you add them, end up in the same place. So that gives you a general idea how to calculate. All right, go for it.
Great. Oh, Shannon, we lost your audio. You have earphones
There
on.
it is.
There you go.
Okay, back.
Can you pull up that slide 12? So we can talk about very important virus exclusion that the carriers are relying on to try to deny the claims. Or do we lose Todd?
There
There
he is.
There he is.
I'm here. I just don't see the slides
Number 12.
numbered, so I'm
Oh,
going slow.
Keep going. Keep going.
Which
To
direction?
the right. You're right. Forward.
Left.
Forward.
There you go.
Okay, right here.
This
No,
is it.
yeah.
Sorry.
Yep.
There you go.
I'll just keep pushing buttons till we get it right. How's that?
All right. So there's two ways. There's two different places that you can find a virus exclusion in most of these policies. One is within the actual policy itself, and the other is it's added as an endorsement to the policy. It's an ISO form, as Bruce was talking about earlier. And so we've got some examples of the language that you typically see in these exclusions. Now, the argument that we've been using is that, and this, someone asked earlier about what if I had the actual virus on my property? That could be a physical loss or damage. However, if you have it actually, evidence of it at the property, if you have a virus exclusion in the policy, it could act to, keep you from getting your policy benefits. The way that we're approaching this virus exclusion is the fact that if the virus isn't actually present at the property, then it doesn't apply, because when we're arguing for coverage for our clients for some limited coverage, let's say for limited coverage for mold or limited coverage for fungus, we have to prove, and the law looks at whether there's actually mold or fungus present at the property. So when we want to get our coverage for those limited coverages, we have to show it's actually there. So our argument is that's the same for the carriers. If they want to apply this virus exclusion, then they need to prove that it's actually at the premises. And for most people, there's no evidence of that, right?
So
civil orders are to, what's that?
So opinions aren't facts?
Well, this is an argument, and this is the reason why you're going to see more lawsuits. The courts are going to have to rule on these issues. And so, but I just wanted to point out to everybody, if you have a virus exclusion, that doesn't end the analysis. And so the other part of the argument against the virus exclusion is the way that most of them are worded. They argue, let me back up. Most states require, if an insurance company wants to avoid coverage with an exclusion, they have to make it very specific. And so it can't be some vague exclusion. And so a lot of these virus exclusions do not specifically talk about the threat of the virus or the threat, the possibility of it happening. And so what's interesting about that is in other areas of the policy, they actually exclude the threat of something. For example, in your computer coverage, that the threat of a computer virus is covered. In where you have the exclusion for pollutants, the threat of a pollutant is excluded. So they know how to use the word threat of, and they haven't done that in most of these virus exclusions. So that's the argument.
Or exposure, or neutralizing, or spreading, allegation, pandemic, all of these words that are in other areas, like you said, they're lead paint, asbestos, mold, fungi, all these things that we know, and they know, because who wrote the policy again? Oh yeah, the insurance company wrote these policies, right? So, you know,
I think Scott, we should take some questions.
yeah, let's take some questions. Let's see. These loss of rents may continue for several months. Should we file the claim now, or once we truly know the extent of the rent losses, do it now? That's Barbara Carley.
And then someone, Benton Mahaffey, sorry if I didn't say your name correctly. If you have the actual COVID that's people have tested positive in your building, that could be some evidence of to kick in the virus exclusion. But there again, it would be physical damage. It would be physical loss. But keep in mind, if the carrier wants to use the exclusion, that's their burden to do.
Or option, yeah. How would you address losses at a hotel that has gone from 85% occupancy to 10?
I think that might be for Bruce.
Yeah.
Well,
that's from
I mean, it is and it isn't. As far as the calculation of loss, you know, I look at the STAR reports, which gives comp reports. I use profit and loss statements, but still, it's going to get down to the coverage issue, which is more Scott and Shannon's area. But I mean, calculation of I do a lot of hotel losses, and I mean that's no problem as far as calculating the losses. Again, it's the coverage if it relates strictly to the COVID.
I think just in a conclusory way here, everyone's policies are different. Even within the same carrier, the Hartford policies, the nationwide policies, they're all a little bit different. People have different exclusions or different coverages. So it's really important to look at the policy, have a professional look at the policy with you if you need that. Ask your agent to tell you to submit the claim for you. Submit the claim and get the denial letter and let them explain to you why they're not going to pay the claim. I have not heard yet of any claim being paid.
Yeah, me neither. So, well, I think we've covered it all, and I just wanted to thank everybody for putting this together. And Todd, do you have any?
Yeah, let's do this. I maybe go around the horn here quick and just add in any final thoughts. If anybody has to drop off right now, remember we're recording it. But I also want to take a moment to throw up everybody's contact info, if that's okay. Okay. So just we'll start with Scott and give us some final thoughts, and we'll work through the contact info that way.
Sure. I mean, we're making the arguments. We're positioning clients' arguments in support of coverage, and asking a lot of questions for insurance companies to support their positions. I feel like we've got at least a dozen different things that reasonably support a policyholder's claim for coverage, and where this goes, how it ends up, nobody really knows. But if you have questions, I can be reached at Scott at Insurance Claim Recovery Support. Our website is insuranceclaimrecoverysupport.com. I made a link available that talks about business interruption losses, and my number direct is 832-725-2878. We're happy to help anybody that needs the help.
That's great. Shannon?
Yeah, I would encourage everybody, if you have a big loss of your income due to all of this, submit a claim and see what they say, and then get help from a professional. And, I've told all of my clients that we're in new territory, but I think we have good arguments. I'm not buying the arguments from the other side. And so, you know, as far as for my clients, I'm going to fight for them and see if we can get the coverage in place. And so I would suggest everybody submit your claim.
Bruce, you're last but not least.
Okay, I appreciate it. Well, I think the most important thing at this time is to find people that deal in property insurance. There's attorneys out there, there's adjusters out there, there might be liability. Find people that do this on a daily basis. It's like, to me, I always give the example, it's if you have a heart attack, you don't go to a pulmonologist, you find someone that deals with the heart. And that's the situation here. So find people, whether it's attorney, public adjuster, or CPA. Not all CPAs do this work, very few do. So find someone that knows about this. That's my word.
Yeah, very good.
Good advice.
That's great advice. Well, thank you, everybody. Again, this will be on our YouTube channel if you missed anything. We'll also have it on our website. We'll send it out to these presenters. You have everybody's contact info, including mine. Thank you. This was wonderful. I really wish we'd have had 1,000 people on today. I just think some people look at the headline and say, oh, this doesn't apply to me. I'm hoping we can get this video out to more people, because I love that you all are chasing it down, and I think it's going to be a positive for a lot of people affected. So
Good.
thank you.
Thanks, Todd.
Yeah, thanks.
Thank you.
Thanks, everyone.
All right.
Thank you.